Call this work session to order. We'll start with the. You can settle. We'll start with introductions with you, Ms. Quinn Davison.
Austin Quinn Davison, Assembly.
Dean Gates in the council.
Karen Norsworthy, Employee Relations Director.
DNS Department of Law. Heather McAlpine, Office of Equal Opportunity.
Barbara Jones, Municipal Clerk.
Forrest Dunbar.
Felix Rivera.
Suzanne LaFrance.
Pete Peterson. John Weddleton. Dick Train.
Thank you. Mr. Croft, are you in the back there? Mr. Constant?
Yeah, Constance gone.
Okay. Okay, well, I will, because Pete asked the question, I was going to turn it over to Ms. Jones, but I'll start instead and then turn it over to her because she and a number of other people have done great work on this. No, this is not connected to any incident that has happened. This is a sexual harassment policy. We started working on this actually in June, was when I first introduced the concept. And it was motivated in part by what I saw down in the legislature, where they had some issues, had difficulty enforcing things, had difficulty with the policy there. There are also some legal questions about whether or not the municipal-wide sexual harassment policy truly applies to the Assembly Department and particularly applies to Assembly members. So that's why we have started creating this as a policy. It's not an ordinance that applies outside of the Assembly Department. So it's in resolution form, so it can be introduced and passed on the same day. It happens to be the last day that I will be chairperson. So with that, I want to turn it over to Ms. Jones to start walking through this, and then Mr. Train, I'll put you in the queue after Ms. Jones has done the initial introduction.
Thank you, Mr. Chair. As some of you know, this is kind of where I grew up in the law. I worked in employment law when I graduated from law school in Colorado, and then when I came to Alaska when I was in private practice, and then I worked at the Equal Rights Commission enforcing the municipalities' anti-discrimination laws for 12 years. So this was really fun, Mr. Chair. Thank you very much. But as you also, I hope, know about me, I believe in the team concept, and when the chair asked Dean and I to work on this, it was a pleasure, of course, to work with Dean as a team. And I also invited Karen Norsworthy and Dee Ennis to get involved, and the chair invited Heather from OEO because Heather was part of our original team. Since OEO has a huge role with discrimination within the municipality. So we all have a little different roles here, but the way I started this is I took the existing municipal policy against discrimination and harassment. And the reason is the policy has been vetted. It works. The lawyers have already reviewed it. So it seemed like that was an appropriate place to start. And then we just went from there and made a few changes. I think the major changes are that the policy covers the assembly members and the assembly aides. I think that's a question that you get to ask the lawyers and the experts whether the assembly members are covered by the existing policy. I choose not to answer that question. So that is one issue that I think the aides are probably not covered. I think that's probably a little bit clearer. The second question is what happens if an assembly member is accused of harassment or discrimination under this policy? And that's always a difficult question for all of you who are employed or have been employed. Whenever the boss is being accused, it's difficult to do something about that. The assembly department is a small department. It would be difficult for us. As Dean stated in an email to the group, and he can probably discuss that a little bit more, some legislative bodies, like the state, we looked at their policy, they have a human resources department for just the assembly. We don't have that. We rely on Muni Legal and Muni ER and Muni OEO. So that's why it seemed important to connect with that. However, there's potential conflict. I have a feeling as uncomfortable as the ombudsman would be, prohibited by code, to investigate an assembly member, it would probably be uncomfortable for them as well to investigate an allegation against an assembly member. So we copied the provisions from the state legislative policy that the chair was referring to and required an independent investigation is the term that we used in here. So those are the key provisions that I would say assembly members and aides are clearly covered. There's an independent investigation if an assembly member is accused of discrimination or harassment. And then I think we can open it up for questions from you. The one other thing I'd let you know, that Chair asked us to do this on a Wednesday. The document is a draft. He anticipated that you would make changes and that we would put those on an S or an A version of this AR on Tuesday night. And Dee Ennis and I have already talked, and she has a couple of suggestions. So we're looking forward to those suggestions here.
I should also point out that this is only sexual harassment and sex or gender-based discrimination. There are obviously other kinds of discrimination and harassment. There's race-based or sexual orientation-based. There's a variety of different kinds of harassment and discrimination. I want to keep this one narrowly focused, just one policy. I know those other ones exist. I suggest that we create other policies for those if and when we do that. Again, because we have a defined municipal sex discrimination and sexual harassment policy, and I wanted it to be as sort of close to established law as possible. With that, Mr. Trainee, you had a question or a comment?
Thank you, Mr. Chairman. It's not just assembly members or aides. If you take a look down here, Anchorage Assembly, Assembly Council's office, Municipal Clerk's office, Municipal Budget's office.
Yes.
When you apply to the Assembly,
Yep.
they're a separate division of government.
Yep,
So it's everybody within our particular division.
that's exactly right.
And because of separation of powers, who's going to investigate? Because I don't want the investigation done by the other branch of government. Are we going to do the investigation?
Well-
Or are they going to do the investigation for us?
So, Mr. Chair, there's two parts to that, and here is the difficult part of it. I would argue, and I'm arguing, so somebody can disagree with me. That's what a good lawyer would tell you. I'm an employee, and Dean is an employee. The municipality as a whole has an obligation to have a harassment-free work environment. Dean and I are entitled to that. As a result, I would say that we most likely are covered by the existing municipal policy. The dilemma happens when something happens and discipline is required or leave is required under the existing policy. And then it's up to the chair of the assembly. And that's where it gets a little dicey under the existing policy, and we're just trying to make that clear.
If you look on page 3, Mr. Trainee, it says the presiding officer, the chair, may request assistance from OEO, ER, or municipal attorney's office. So the chair may choose to get assistance from the other branch of government. Or if you look at the next 2 pages, they may also contract with an outside investigator, and then if it involves the chair themselves, then the vice chair will act in their capacity. So I think I hear what you're saying on separation of powers, but I think it's also a practical question about capacity, right? And so at the state level, I think it's the Legislative Affairs Office. They have their own quite a large office that deals with the legislative branch of the state, right? We don't have something that large or in depth here at the assembly. So I think, speaking as the chair now, and I won't be the chair when this goes into effect, but that if I came across something like this, I would want actually to rely on the subject matter experts they have at the municipality to do this kind of thing, to sort of supplement my own ability to do an investigation. So that's why we wrote that's one of the reasons why I'm comfortable with the policy
Let me
written
give
this
you a
way.
follow-up question, of course. Where would you envision let's say there's a complaint and you look into it.
Yep.
Who makes the final decision on the action taken against that assembly member if they did in fact commit it. Because that normally should be the whole assembly, if we don't reside that power into the chairman. Because chairmans come and go by 6 votes.
Well, we have, let me see here.
It's on page 6 of 7. It's the it's the paragraph right before the numbered paragraph 9.
Well, but I think that's all vested in the chair, is that correct?
No, it is not.
Okay.
I think that, well, I think you're correct that but I think that one of the proposals was that the assembly should be able to see it, but that's only if it's the presiding officer, the chair, or the vice chair.
So that, I mean, that
So,
might be
so you
something-
are correct, Mr. Trainee. The way that it's written right now, if it's an assembly member, it goes to the chair. And the reason is the chair is the only one that has any ability to do anything, and the only thing that the chair can do is take away a committee assignment or
That's all we can do.
or a liaison, and that's what it says here. That's all the chair can
3 years
do.
ago, we had an assembly member that, anyway, had done something, and it came to the assembly, we had to decide what we're gonna do.
Yep.
So it's the body, all 11 members have to decide the action they want to take.
But we don't actually have-
Decide just the chairman.
We don't have censurability, do we?
Through the chair, at the time that I believe the issue that Mr. Trainee was talking
I'm not
about
naming names.
is that the assembly, and we must have asked either Dean or Muni Legal, and it was determined that there's nothing in the code that allows the assembly to censure another member.
Generally, the chair is the responsible official for the assembly member. So if the assembly member was the problem, then you probably do have some power. But the other problem here is if the victim is an MOA employee, they have to report up through our policy. And so while I absolutely applaud you for doing this, that we need to spend some time making sure this is consistent, because if an employee discriminates an assembly member, the assembly member discriminates against another assembly member. We have about 3 different situations with different results. And yes, there's separation of power. It's a great policy, but we really have to clean that up a little bit. That's not really identified here.
I just think there's more work needs to go to the assessment. It's a good idea.
Yeah.
Mr. Rivera.
Thank you, Mr. Chair. Speaking of censure, that paragraph that was brought up by Ms. Jones on page 6 of 7, the last sentence there says, if legal, a form of reprimand, censure, or other penalty. So I'm assuming because it's not legal, we can't do it. Or why is it
Well,
included?
again, it depends who the parties are, who's the perpetrator and who's the victim. So that there's different processes, and we need to make sure they're consistent.
The second question I had, I think I know the answer, but I just want to make sure.
Yep.
So under the definitions of sex discrimination and sex-based harassment, it says based on sex or gender. I assume that gender identity is wrapped into there.
It is under federal law. I'm not sure it's that clear from your policy.
That was sort of my tension. I mean, I don't want this to be a sexual orientation-based discrimination policy, if that makes sense. If someone's discriminating against you because you are gay, I don't know if that, or whatever.
Right, Mr. Chair, but there are big differences between sexual orientation and gender.
Exactly, and that's what I'm trying to make sure that there isn't anyone, there's no question, it doesn't matter where they fall along any kind of spectrum, they have the right to pursue these options. And that was why I put that in there. But, I mean, if you have thoughts on how to clean that up, or if anyone does, I'm certainly open to them.
Mr. Rivera, could you please state your question again? It was...
Sure. So if you want to look at the page specifically, page 307 of the policy, and under sex discrimination and sex-based harassment, those definitions specifically state based on sex or gender. And I just want to make sure that it's either assumed or otherwise that gender identity is included in those definitions.
And I guess that's sort of...
Through the chair, the case law is actually quite old, and I have to go back into my brain to pull out, but I believe it's Hicks v. St. Mary's Honor Society, and it's also the Price Waterhouse case. Those are really seminal decisions in the area of sexual harassment, And what those cases talked about was how sex-based stereotyping is illegal under the sexual discrimination laws. And in that case, it was a woman who didn't wear makeup and who was considered aggressive. Men were promoted if they were assertive, but women were not promoted because it was not considered to be an appropriate female gender-based role. So in my opinion, those provisions have always been part of the law on sexual harassment. I have not stayed up on this area in the last few years, but you can correct me if I'm wrong.
Well, I think a lot of the federal law has written stuff like gender identity into the word sex. And it's not clear, and I think your point is well taken. Are we going to make it clearer? And maybe that would go in the definitional section.
Well, and just to add one final note, I think we have a training administration federally that could make some significant changes to whether gender identity is included under sex. So I think it might be good for us to make that change.
Are you suggesting, we have the word gender already in here, are you saying that gender and gender identity to you are sufficiently distinct that we need the word identity in there as well?
I think that as long as case law and it's under perhaps other policy or definitions, that we can link the two. If it's linked somewhere else, then I'm fine not having it linked here. But if it's not linked anywhere else and it's under law would be seen as two different things, then I'd rather make it more explicit.
Okay.
Through the chair, Mr. Rivera, would it be satisfactory if we used gender stereotyping? If we could think about that, gender stereotyping?
Yeah,
Okay.
Ms. Clinton.
Thanks, Mr. Chair. Could we possibly just say based on sex or, in the definition, based on sex or gender, including gender identity? I agree with Felix. I think we should just be direct about it if that's what we're speaking to.
Yeah.
I don't know if that works in D and others can evaluate it, but I think
If that is something that makes sense under, our sexual harassment policy, or I guess if that's something that legally makes sense, then I am, as a policy matter, totally comfortable adding that in there. Mr. Dyson?
Yeah. What I don't want with any of what we're doing with this is people using, please, none of what I said is pejorative here, I'm struggling, but using the fluidity of gender these days as a positive defense against a criminal charge. So if some young woman thinks that I was inappropriately touching her, here, and charged me with it, I don't want me to be able to say, hey, I'm a girl, and that kind of touching wouldn't have been offensive to you.
Well, I'll say two things on that. One, this is not a criminal policy.
Yes.
And two, there have been in the past sexual harassment policies that talk about, male on male, female on male, female on female. We took that out because for this policy and sort of the modern world, and certainly to me, it doesn't matter. It doesn't matter if it's a man on a man or a woman on a man or any spectrum,
Sure.
any way anybody identifies with someone else. It doesn't matter.
Yeah. And,
Person on a person.
and that I think is appropriate.
Okay.
Yeah.
Thank you, Mr. Dyson. Mr. Train.
Mr. Chairman, D, couldn't we structure this so the complaint's made, goes to the ethics board, then the ethics board comes back to the setting? Because right now the ethics board can look into things and they can't get it out in public.
I would say, do you mind?
Yeah.
I would say no, because the ethics board just has no expertise in this area. They have no ability to investigate. So I would say no, that's not a good idea.
Yeah. Ms. Quinn Davidson.
I have a question about 6. This is a question I raised when Forrest and the others were reviewing this and provided some edits, which was really some things here. So 6, A2, and that whole process of 6A, what happens if the offender is the presiding officer or the assembly office head? I feel like that language sort of reads as if that's not the case, but I just want to make sure that it's clear and perhaps it is in a different section, that you don't have to report to your offender if the chair is the offender.
Yeah, and we need to look through that, plus the word supervisors in here a couple of times, and so, yeah, I think that's a point well taken. We just need to clean that up a little bit.
Ms. Jones?
On page 4, right above subparagraph C, Roman little I3, if the issue involves the presiding officer, the vice chair
Vice
will
chair, yeah.
act for the presiding officer.
Yeah, we actually spent, I remember in our discussions, we spent quite a lot of time thinking about if the chair is the offender. So I think that is in here. The issue about reporting to your chain of command, if you will, I'm not sure. I thought we had something in here on this, Mike.
Mr. Chair, I agree with you. I thought that we made a change so that the employee can report to a supervisor or the presiding officer. So that would address it if the supervisor is the one that's doing the harassing. The third reason that I think it's
Oh,
good.
here it is. I'm sorry.
Where
on
is that?
Page 5A at the top. They can report
Yes.
to their supervisor, the presiding officer, OEO, or the employee relations department. So there are multiple ways that they can access.
And Mr. Chair, I believe that that is required in federal law, that employees have an ability to report sexual harassment outside of their chain of command. And for that reason, I recommend leaving OEO in the policy as long as the municipality is willing to do that.
Yeah, go ahead, Ms. Quinn Davidson.
And at the end of 6A, little 2, you probably see that there's a complete sentence there.
Where?
If the allegations are.
Oh, yeah, look at that.
So something needs to be filled in there. And then on the next page, under C, it says the OEO may. Is it the case that the OEO, if requested to be involved, shall do these things? Because that really makes it seem like it's the OEO's decision about whether they want to help out. Is that really what we mean?
And Barbara and I and labor attorney Blair Christensen discussed this today, and we do want to have something where they just don't, OEO maybe will have to report to the municipal attorney's office or something. And just for everybody here to understand OEO's role, which we've really tried to define in the last 6 months, is that it is an informal agency. It's our internal agency. It's not a compliance agency. It has 1 month to try to resolve things. And when I say that, an employee will say, it's not fair that I can't use my earbuds at the front desk, and come down to OEO and make a complaint because she's a woman, that's some type of discrimination. That's a perfect case for OEO to work with and say, you know, it's sort of borderline of frivolous. Let OEO work with those type of cases internally, not that everything that comes here has to be elevated to an independent investigator. So we also want to leave open some of the more informal processes, which is OEO.
So D, when it says under C, little 2, OEO may refuse to attempt to informally resolve, I saw that repeated a couple times, and to me, since I don't know what you just described at OEO, it was a little confusing, like it informally resolved versus their other process that's more formal.
Right,
So I
and-
wonder if we should we just take informal out, because they're resolving it using their process, whether it's formal or informal, and to me, it makes it sound like it's some sort of half-assed thing, you know, like it's not a real investigation.
Well, it's not a real investigation. It's
Okay, so maybe that's
it's a more of a resolution. They are only allowed 30 days. They don't go on for 2 years. They don't have investigation expertise. So it really is meant to be informal.
Okay.
And if they can't do that within 30 days, or they right away recognize it's out of their bailiwick, then it would go elsewhere.
So maybe it's appropriate.
And maybe that flags the employee that it is informal. I mean, we've gotten into a lot of trouble in the past between OEO sometimes being formal and sometimes being informal, and what do their recommendations mean? And so we really said, wait a minute, this is our informal internal group that may or may not be helpful.
So through the chair, the C little I is a copy from the existing policy. However, in that, it's OEO shall, all right? And so if the administration is willing, that OEO shall assist employees, but we would need to make clear that the definition is that employees do not include assembly members. That would be something that would require, because little I2, that.
Well, can we get page
Oh,
numbers here?
yeah, page 4 of 7, C, little I, double I. That one right there should probably start, if the allegation includes an assembly member, OEO, and we probably will say shall refuse in that one as well. Because the issue is, if it involves an assembly member, we shouldn't be doing an informal resolution, even if the allegation is an assembly member told me I couldn't wear my earbuds at the front desk. We want to be cautious about those, and we want to take them seriously, because they are serious if it involves an assembly member. So we can, I think we can fix that. Would that help if it was shall? And okay.
Sure. I have a couple more. Is it okay to
Yes.
just keep going? Okay. Under D on the same page, the when appropriate comment, is there guidance on when that's appropriate? Is that in some other policy, or how do we make that determination? And then my second question is E little I, when it says upon request from whom?
Through the chair, those are in the existing policy, and so Karen, could you help us with those?
So when we have an allegation of any type of sexual harassment, our first role is we connect with Heather and OEO, and then we launch a joint investigation, formal investigation through that process.
But what is the when appropriate part?
So, I don't want to say this. So depending on, sometimes it might be someone in the public, maybe an applicant, something along those lines. They may not want us to, we're starting on a process, and they may not want us to actually continue. So then we're not going to do that. Depending on the level of the allegations too, we may elevate it, and we may be working with the municipal attorney's office as well.
And you haven't seen that sort of language be used as an excuse not to investigate?
No.
And then is the upon request, and you can fix that 1D actually, since I saw this, did it say from the municipal attorney's office or something? Here, I get you. It's under E, a sex discrimination upon request. So I'm just wondering who, is that from the presiding officer or whoever else is involved? Or who's it from? Okay, cool.
Through the chair, that's in the existing policy, so I anticipate that it is, I understood that to mean upon request of the Employee Relations Department or OEO.
Okay.
Did you have a hand?
No, that's basically it. It's just that any of these groups can always request assistance from the municipal attorney.
Thank you. Ms. LaFrance and Mr. Train.
Thank you, Mr. Chair. Ms. Jones, would you speak to assembly aides and interns and where they fit in this, if they are considered in the definition as employees or assembly or voluntary assembly members?
Through the chair asked us not to include assembly interns, so they are not included in the policy.
Interns, but not aides. I mean, aides are included.
Right. So as far as aides, we followed the municipal policy. In the municipal policy, it says that volunteers and interns are considered employees for the municipal policy. So as a result, what we did was say assembly aides are considered employees for this policy. They are not, but for this policy, that's what we're proposing.
And the reason I didn't include interns is because our intern programs are very informal, and some people have interns, some people don't. And I'm not, I kind of, a couple years ago, sort of set up an internship program that that Felix has helped run and our aides have helped run, and it's recruited some kids from UAA. But they never interact with the clerk's office. that I'm aware of. They certainly aren't paid or categorized in any way. And so it just felt to me too informal to be brought into this kind of formal process.
We did orientation for them, but that's it.
Oh, you
I've
did?
never,
Oh, good.
I've never seen them since.
Right.
And it sounds like they're covered, did you say, by the meeting policy, because that covers volunteers? No.
No.
So separation of powers question, so the muni policy does cover interns and volunteers, but it's debatable whether the assembly department is covered, so I'm just going to tell you, I don't know that.
Yeah, I mean, we could think about adding interns to here, but it's, I mean, my understanding, we was thinking about the interns at the municipality is usually a much more formal process than our interns. Like, they often have a desk, or they're here for a number of hours a day, versus our interns where, you know, I don't know how y'all are used to the interns you might have. I see my intern probably once every month and a half, and I'm mostly just emailing them like little assignments. So.
Of course, one definition is hard if you don't have access to the city computer databases.
Yeah, also true.
We've had that issue before we've dealt with that. We've not given our aides, which are independent contractors, access into the computer system. They don't have their own password, they don't have their own login.
My other hope is that at least with UAA interns, that they would have a method to report at UAA if something was happening. But Ms. Quinn-Davidson?
I agree with how sort of formally engaged the interns are, but I'm wondering whether that's the right standard to decide whether they should be covered by a sex discrimination or harassment policy, because we don't want to incentivize
Sure.
if there's someone who's not covered. I'm just not sure if that's the right reason to not cover
My
them.
thing, if we do cover them, then I think we have to train them. I think that every intern would have to be trained on this policy. I assume our aides are going to be trained on this policy. I know that we are all going to be trained on this policy if we pass it. And we could train the interns too, but that would be a level of formality that I haven't contemplated for the internship program yet.
Yeah.
Dick?
Mr. Chairman, normally, public procedure manual is dealt by the city, does not come to Assembly for approval. The mayor or city manager simply signs off. It's a fact of law, pretends it deals with that branch of government. There's no reason you as chairman can't sign approved by. It does not need to go in front of the entire assembly. You can simply sign this off as chairman of the assembly. It sets a public procedure manual for our branch of government.
Interesting.
And if you want to go the whole route,
I think the clerk might be disagreeing with you. This is our disagreeing phase.
No,
the mayor could veto this. Not this one would, but I've got legal opinions. The mayor could veto any action we take.
Sure. And then we could override them, and that would be a fun fight.
Well, actually, it wasn't my disagreeing face. It was, in fact, Mr. Trainee has already done that in a different circumstance. You have an individual assembly member account, and there is a memo on file that says that you can use your individual assembly member account for an aid or for travel. And that is a policy of the assembly, and the chair at the time authorized that. So you do have some policies, but that's the only one that I know of.
But you could, in fact, Mr. Chairman, do this. If we agree to it, just move on. I'm saying you don't have to do this. You don't have to do a vote on this at the assembly chamber. You've got the ability as chairman.
Well, I appreciate that, and I appreciate you calling for me to take up the mantle of dictatorial power, but I think I'm going to I still will keep this on the agenda. If anybody I hope we'll have some revisions before Tuesday night. We'll get things hammered out. I would like to pass it on Tuesday night. It's my last day as Assembly Chair. It's something it was one of the priorities I set when I was elected Assembly Chair. And unfortunately, we had things like a special election and an earthquake and some other things that delayed it. But no, I appreciate what you're saying, Mr. Trainee. But I think I want to have, given that I want this to endure beyond my time as chair. I would like us to vote on it, and then the next chair could repeal it, perhaps with a stroke of the pen. But perhaps there would be some political consequences to doing so. But okay. So getting back to the substance of the the resolution. Is there anything else that people want to talk about, or any specifics that we want to change before Tuesday night? Mr. Weddleton?
This is the puzzle here. So, page 7, second paragraph. Employees will not be granted administrative leave to file a complaint with the compliance agency. Page 4, street level. Page 5, D, the employee may request administrative leave. Is that like take an hour to go, you get to clock out for an hour and then clock in if you go to one group but not the other? Or is that a big deal?
It's a great question. Those are in the existing policy, and I think Karen Norsworthy is going to be able to answer those for you. There is a distinction. One is I'm going to OEO to file, and if it was one of my employees, either the chair or I could approve that administrative leave. But if it's to go to a compliance agency, the Equal Rights Commission, the State Commission for Human Rights, or the EEOC, then only OEO and the Employee Relations Director can approve that. And I am sure Karen can tell you why.
So most of the time, well, I'd say like 99.9% of the time, when we're doing administrative leave, you hear about it in the news with police officers. After an incident where they've discharged their weapon, there's 3 days of administrative leave. We do that when we're doing investigations, and it's an investigation where we think the actions or the behavior of the employee may prohibit them from doing their job. We will put them out on administrative leave. So administrative leave is typically used when we have an issue with potentially somebody's ability to do their job. The other thing is when we're looking at asking somebody to go through their supervisor up through employee relations to go file a complaint with another agency, think about how that's going to roll with the employees. There could be some problems and challenges there for them even asking for that leave off. The other thing is then we're really asking for somebody to take it outside the municipality to file actions against us before first taking care of it internally.
So partly
one
it's
of-
incentivizing them to stay internal, or at least to read.
Right, and the other side of it is, if they are using their own leave to go to another agency and let's say the allegations are sustained, they can always come back as part of what they're asking for, and that is to have their leave reinstated if they use their leave during that time frame.
So is it asking for a month off or a week off, or you're just saying an hour off? Can I
It
have
depends.
An hour off to go report?
If an employee is going to go out to an agency, they typically are going to be using their own time. In some cases, some employees may do it on their own time. On our time, what we're paying for is go and make a complaint at one of the agencies. We may find out about it later. We typically don't know when they're filing at another agency. We find out sometimes many months later that somebody's filed. So you don't really see that admin leave. And again, if in the results of if a complaint is sustained against us, part of the resolution in that is that we could always, reinstate their leave if they use leave during that time, but not up front.
Ms. Ennis?
Yeah. I was also going to say that many employees, if they're going to file with one agency, file with 4 of them. And so they're going all different directions. So it sort of opens a Pandora's box. And then also the claim when they go to an attorney, why shouldn't that be covered? So it's sort of a Pandora's box I think we don't want to get into. One of our few wage and hour claims in the past couple of years came to the Department of Law was just such a person who had gone to 4 different agencies, and did we not incorrectly pay her, and it was a nightmare.
Great, thank you. Any other questions on the policy?
Through the chair,
Oh, yeah.
Mr. Weddleton, if someone would go to OEO to where the leave would be granted, I can't imagine that would be more than a few hours. And I think that's why that one is much easier to stay internal, and the other one could be, it could be unlimited.
Can I say something?
Yeah, Ms. Ennis.
The other thing is, you know, many things that come to OEO really can be resolved fairly quickly. They're not nefarious acts of sexual misconduct. And so we want to encourage that filtering right there. And that's why OEO can then also send it to ER or municipal attorney when they see it's more of a problem. So it's a very helpful service to the municipality to have that filter.
Ms. LaFrance.
Thank you, Mr. Chair. So concerning the chair's role and discretion to engage OEO, the chair would only be dealing with instances that involve assembly members. Is that correct? Because
No.
members of the
And AIDS.
Oh, interesting.
because
Well, no, the chair also gets involved when an employee reports.
But see, that's the problem where we need to work on this policy, because the employees have an obligation to go up a different way. And so there is, it's difficult, and we need to make that consistent.
It's already the case that if an employee reports, the chair gets involved.
So, Mr. Chair, and to Ms. LaFrance's question, I believe this provision here under 6B for responsibilities, let's say that an aide does come to the chair and say, hey, you won't believe what happened to me. I was in City Hall one night and I got sexually assaulted. And the chair says, we're calling the cops, we're calling OEO, and the person says, no, I don't want you to do that. The chair has, here, I would argue the chair has an absolute obligation, and that isn't clear here, but because the duty is the municipality's duty, and it's the municipality's duty to provide a harassment-free environment, I would say that the chair must contact someone in that circumstance. And that's probably why it's here. We did change the shalls to may, but in the municipal policy, the department director shall request assistance. Mhm.
And I think it was changed from shall to may, because it was done by the assembly team, to respect separation of powers, because really should the assembly tell OEO, employee relations, or municipal attorney's office how they handle these things? Not really, because separation of powers. And that's, again, that's just why we want to make this consistent. This is a great effort.
Ms. LaFrance.
Thank you, Mr. Chair. And I guess there's something about the May and the 6B that gives me a little bit uncomfortable. I guess that scenario, if it was an aide who went to the chair who was dismissive, for example, I mean, what would be the recourse then for that aide? I mean, not that happened, but.
No, it could happen. The aide, I mean, so I think the aide has the ability to report elsewhere too. I mean, that was what we just had that conversation about employees being able to go to OEO or ER or their supervisor or the. But you're right. The supervisor and the chair in the case of the aide is the same person, right?
It could be, but it could be someone else's aide came to you. So
Right.
yeah.
Right. So you could go to your own assembly person, or you could go to you could go directly to ER. You could go to OEO. And we have to train. We're going to have to train our aides to let them know that if something happens to you, you are able to. You don't have to go to the assembly person, especially if the assembly person is someone you're not comfortable with, or they're the perpetrator. You have these other options available to you.
But it's then comes back to the chair for the disciplinary piece, right? Or
If it's an assembly member, yeah. Is that
It
right?
always is going to come
It's
back
gonna
to you,
come to the
Mr.
And
Chair.
I think it's kind of an irreducible problem because we are a separate branch of government. If it's an assembly member, if it's the chair themselves, then it comes to the vice chair. And there's also a thing in here where the report goes to the body in an executive session to decide whether or not you want to reorganize. On page 6. If the complaint is against the presiding officer or the vice chair, the report shall be provided to the remaining assembly members which may receive it in an executive session, so they can choose whether to pursue the organization of the assembly. We gave some thought to how do we enforce this. I mean, and look, the truth about this is, for a lot of it, the enforcement mechanism on assembly members is political in a large way. Not, I can't take any of your money, you know, and I can't demote you, and I can't fire you.
Take out committees.
All I can do is take you off committees. If I, you know, all the chair can do is take you off committees or take you away from, like, you're no longer the ACBA or whatever it is, representative. But I think there's sort of understanding that if we went through this whole process, there's a good chance that the public is going to find out about this, and then the public is probably going to be the one who ultimately holds us responsible.
Mr. Chair, in my discussion earlier today with Dee Ennis and Blair Christensen, one of the ideas that we had, there's some concern about having the victim approve the final report and releasing it to the public. So what we discussed instead was having an executive summary of the final investigative report from the outside investigator that would be somewhat sanitized. So it wouldn't name the victim, but it would name the assembly member. And then that would be much easier to publicize than a final report that you know, could do more harm to the victim than necessary.
Ms. Ennis and Mr. Tran.
But there was also the concern that the administration does not give a report to the victim before it's discussed internally, because you may not agree with those investigations, or you may, or there's additional facts that need to be developed. So to say that it's going to go right to the victim, we don't do that. It's internal. At some point, it's going to come out, but it's so that's another concern we had. And then the issue about a final report may be released to the public. And I guess the assembly, you're not really subject to the personnel rules, so because it's sort of a personnel report, and I think anybody could do a request for information, and you're high enough up that it's not going to be protected. But anyway, there was some. We want to think a little bit about that too, and it's not a separation of power issue; it's just a overall confidentiality of these things.
And through the chair, that provision is out of the legislative policy. So the legislative policy, they do give the draft to the victim and to the alleged harasser. But I think that that's prudent to allow, it would be the municipal attorney and the chair or the vice chair that would be reviewing this investigative report. And I think that it would be really important to get it right before it's released to anyone. And so if we make those tiny changes, not provide a draft to the victim, and have an executive summary be prepared to release to the public, I think that would be a better policy than what we have written now.
Mr. Trainee.
Just the term you're looking for, I think, Mark, is redacted on the other government all the time. Issue something with a lot of black lines redacted. That may be what you want.
Through the chair, Mr. Trini, I think redactions are a good idea, but I will tell you that from my experience, everybody knows who the redacted documents are about and what they mean. There's always sufficient information, and then again, the concern is, does that punish the victim again? So I think we could do either, and we could probably include both in the policy, that it'll be a redacted version or an executive summary.
Thank you. So just we're coming to the end here. I wanted to sort of get down to brass tacks in terms of, I think I have sort of largely handed over drafting this to this team here that has much more expertise than I do. And I'm hoping we can have a revised version of this done. How soon do you think we have it done?
Well, by Friday noon is pretty difficult.
Well, I'm comfortable laying it on the table.
I think Department of Law could commit to that.
Okay, so I am comfortable laying on the table something that will be the same. It will have the same front to it, right? It will have the same thing which Dean wrote. This the whereases and the resolution and the title. That'll be the same, but the attached exhibit, which is the policy itself, will be revised in the way that you're describing. and I guess Austin, you're a co-sponsor, so stop me if you're not uncomfortable with any of this. But my plan is to lay it on the table as soon as I have it, and then if we need to pull it and discuss it more on Tuesday night, I'm fine doing that. Or if you're comfortable, if you've read through it, you're comfortable with it, it can be passed without anything else happening. And I think this is like the first time I've ever laid anything of substance on the table in my entire time as chair, so I'm going to do it. Because I care about this, and like I said, I hope this would get done much sooner, but a number of factors outside of our control prevented it from happening. So.
No, sure, Mr. Chairman, you could simply sign the policy and send it forward.
Yes, I could.
You have choices, Mr. Chairman.
I do. I would like to give my colleagues another bite at the apple if there's something here they really feel uncomfortable with, because we're all going to have to be trained on this at some point next year.
That's if you're reelected.
What's that?
That's if you're reelected.
Well, I mean, between January and April, I'm not sure how long it will take to get this stood up. Well, that too, but no, I'm just saying, like, even you might have to get trained before we send you back out, release you back into the wild. And I'm hoping to have buy-in. I mean, because there isn't much I can do if you say, to hell with it, I'm not going to go to the training, or whoever the next chair is. There's not a whole lot we can do except perhaps publicly shame you. But they'll have a lot of enforcement mechanisms, and that's kind of the problem we're trying to get to with this. So I think as much buy-in as I can get as possible, as we can get as possible, would be appreciated. Mr. Peterson, do you want to say something? Okay. Okay. Any other thoughts or comments, Mr. Haberman?
Participation?
Sure.
My name is Eugene Haberman. I represent myself. I follow the public process. The public process done. Appropriate decision made by the governing body is more likely the public interest. I live in that sort of valley. What do I have to say about this whole thing? The more complex and complicated the issue is, the more notice, the more opportunity the public will be heard. But what have you done here? You got this on the second item for the 5 o'clock portion of the meeting. There's talk, the chair says he's never done it late on the table, but he's going to do it on this one at the assembly. And there's no chance for the public to speak on it at all. And I don't mean by written communication. State law requires that all public meetings provide a reasonable opportunity for public to hear. But you got this put in the packet for Wednesday, decided on the 5 o'clock portion on Tuesday, no chance of public comment. And this is not right. Now, it appears that there's what we call a concern about getting the public really engaged on this issue. And that's right. That concern is not right either, because you have a responsibility to connect with people before you make a decision. And of all things is, I'm sorry that the chair wants to get this thing before he leaves, but it should have been brought out way before he left, so he would have been still chair. But this is not the way to do business. And but I want to stress this: that 5 o'clock portion of the meeting, that you've got a whole mess of items there without a chance for the public to address. Fortunately, the City of Palmer council meetings, Wasilla council meetings, and the Borough Assembly doesn't do this kind of shenanigans in this level, and this is not right. They do have a lot of listed items, and they do give some chance to address it, but there's no chance. And then sometimes at your meetings, if you have audience participation at the end, you work the clock, and then the situation is no time for audience participation, so it cannot be addressed. And finally, the words from the chair over the course of time, when audience participation does come up in the regular meeting, the words are, you can speak on anything except what's not on the agenda, except that's on the agenda. So there's another standard situation that you have been condemned. So you need to, I'm sorry you want to connect with this thing, but you're not hearing from the people, and I say to you, you can't take this thing up before the and pass it without hearing from the people, and you're not doing it. And all those items along with it, do it the right way. Out in the borough, they do it in a much more respectful way with that way. And that concludes my comments with 29 seconds to spare, except for one note. Is there anyone that says something I did disagree with what I said, so I can challenge it? Because the last time Constance said something and he wasn't there in the, I want to get that corrected on the record. Anyone? Okay.
Thank you, Mr. Haberman. This is a resolution. They never have public comments. Everything Mr. Haberman said about this being inappropriately done is mistaken. This work session is closed.